Last will and testament on land title transfer question. What happens if there is no last will and testament? Answer: if a person dies without a valid last will and testament, they are considered to have died intestate, and their estate will be distributed according to the laws of intestate succession in the Philippines. This means the property will be divided among the legal heirs based on a specific order of priority established by the Civil Code of the Philippines. Here's a breakdown of the key points. 1. Identifying the legal heirs. Descending direct line. First in line are the children and their descendants' grandchildren. Ascending direct line. If there are no children or descendants, the parents or grandparents inherit. Surviving spouse. The surviving spouse is always an heir, but their share varies depending on other heirs. Collateral relatives. If there are no descendants, ascendants, or surviving spouse, the siblings, nephews, and nieces inherit. State escheat. If there are no known heirs, the property goes to the state by escheat. 2. Distribution of shares. Legitimate children inherit equally. Illegitimate children inherit a smaller share compared to legitimate children. Surviving spouse shares the estate with children or other relatives, depending on the specific scenario. Ascendants inherit if no children or descendants. Collateral relatives inherit in accordance with their degree of relationship. 3. Right of representation. If a child or sibling predeceases the deceased, their descendants inherit their share by right of representation. 4. Estate settlement procedures. Extrajudicial settlement. If the heirs agree and there are no outstanding debts, they can opt for an extrajudicial settlement, involving a notarized agreement and publication. Judicial settlement. If there are disputes, minors are involved, or the heirs cannot agree, a judicial settlement through the courts is required. 5. Estate tax obligations. Estate taxes must be filed and paid within 1 year of the deceased's death, regardless of the settlement method. 6. Transfer of title. After settling the estate and paying estate taxes, the heirs can submit the necessary documents to the Registry of Deeds to transfer the title to their names. Key takeaways. Dying intestate means the law determines how the estate is distributed. The order of inheritance is based on the deceased's relatives, with children and descendants taking priority. The surviving spouse inherits a share, but it depends on other heirs. If no heirs are found, the property goes to the state. The estate settlement process can be extrajudicial or judicial, depending on the circumstances. Estate taxes must be paid before the property can be transferred. It's crucial to understand that intestate succession can be complex and time-consuming. Consulting with a lawyer or real estate professional is essential to ensure the property is transferred correctly and legally to the rightful heirs.